Welcome. We are here at Global Radio and TV, and today we will be talking to you about the importance of contracts in our daily lives. This is Monica Gonzalez with MU Law Firm. Hello, how are you? And welcome back. This is Monica Gonzalez from MU Law Firm. And today I would like to talk to you about the importance of contracts in our daily life, especially in the ambit that affects most of my clients nowadays, especially in the Florida market and New York market, that of the real estate contract. When a lot of my clients have issues with contracts regarding the purchase and sale of real estate, as well as rental agreements. It could be for commercial properties or residential properties. The most important thing to know about contracts, and it's something that I would like to give you an overview, a general overview of contracts, is regarding what it entails to form a contract and the repercussions of signing an agreement, a contract. A lot of realtor agents and specialists rely on the forms that are provided by the board, and regarding any other type of agreements on certain forms that exist in the internet perhaps, but they don't take into account the repercussions of signing these agreements and what it entails for the clients. Most important thing to know is when you're having a contract, informing one, you have to have an offer, an acceptance, and there has to be some degree of consideration. So a consideration is relevant because you could have an offer and an acceptance, but if there's no some degree of consideration, then you don't have a contract per se. Consideration could be monetary, or it could be somebody abstaining from doing something that they would normally do, or doing something for the other party that they would normally don't have to. So that is what is considered consideration in a contract. If you have a contract now formed, let's say you have an offer, like when you submit, I give an example, when you submit a purchase and sale agreement for an apartment or for a house, you submit this offer to the seller. That in itself is telling the seller, I am willing, ready, and able to purchase this particular property under the terms that I'm providing in this offer. If the seller signs that agreement, then you have a contract, provided that there is consideration. And in this particular case, consideration would be the deposit of the funds that the purchaser makes with an escrow agent, and the escrow agent could be an attorney or it could be a title company, a title agent. Now, let's say that the seller doesn't sign that particular offer, but instead sends the offer back with a change on the pricing or any other change. In that case, we don't have an agreement. Even if your client submitted a signed offer, in the original offer that you submitted, a contract, that form, when you have this offer sent back by the seller with any type of change, then you have a counter offer. So it's important to be clear as to that. And your client, as a purchaser, will have to acknowledge the changes, either putting initials in the changes or having perhaps, which I prefer, normally if there's going to be a change, to have an addendum to the contract executed by both parts. In contracts, since we're going to speak in general about the issues that are presented and what is necessary to form a contract, sometimes there are issues regarding the escrow of funds and what happens with those escrow funds once there's a dispute. Let's say the seller cancels and decides not to sell the property, or the buyer decides not to purchase, or perhaps if there is some financing involved in the contract, the buyer doesn't get approved. All these elements are dealt with in the contract. But sometimes you receive a specific situation or circumstance that is not as clear cut in the contract, and when that happens, it is important that all parties involved understand, and especially the agents, because sometimes they feel that it's unfair to them, but the title companies or the attorneys or escrow agents that are holding the funds are held to a high standard of ethical expectations, and there's certain rules regarding how they're supposed to hold the funds for a transaction. Therefore, if there's any type of dispute, it is imperative that you inform immediately the escrow agent of the dispute and avail yourself or your clients, whether the purchaser or the seller, of legal counsel. Sometimes if the purchaser or the seller or the agent doesn't act timely, there could be an action by the other side that could cloud the title. Now, if you have a cloud on the title, later on it will be more difficult to resolve the problem and sell the property or obtain the funds back. If we have a dispute, normally what happens is obviously you try to settle the differences or the situation out of court. If that is not possible, then the contract that is prepared by the board provides for what is necessary to do, and is either mediation, or sometimes there's an interpretive action that is brought into court. If the mediation doesn't come to fruition in terms of resolution, then the interpretive action is entertained with the court. In an interpretive action, the escrow agent who's holding the funds becomes part of that case, and since they are innocent party, in good faith, they're acting in good faith holding the funds, and they are bound by the duty not to release the funds to anybody if there's a dispute. Sometimes when it involves the attorney's fees and the cost, the parties, whether the seller or the purchaser, will be responsible for the expenses for the escrow agents, since they are being now brought or being caught into a dispute that they did not create. A lot of times these disputes are settled, but it's important to obtain representation and not to take it lightly. As to commissions for real estate agents, when there are disputes or there's a cancellation of the contract, it's very important that they read the details of the contract that they're signing to avoid any potential issues, and to avail themselves of legal counsel as well. We are always here to help you, and as I always tell you, this is only meant for an informational brief introduction to the subject that we deal with. However, you are welcome to call me at 305-699-5291, or you could email me at monica@mglawpractice.com, or check us in the website at www.mglawfirmplc.com. Thank you.